The Law Commission has now published its report following the scoping project on the need for reform of the law on offences against the person. We recommend a modified version of the scheme of offences that was contained in the Home Office draft bill from 1998. That bill, amended by the recommendations we make, will produce a scheme of offences that is structured in a more logical manner, will provide greater clarity in interpretation, and will ensure that cases are tried in the most appropriate level of court given the gravity and complexity of the circumstances. Our scoping exercise focused on two main themes: whether there was a case for reform of this area of law, and if so, whether the bill from 1998 was the best model to follow, given that it was based on recommendations made by the Law Commission over the last 30 years. On consultation, we found overwhelming support for reform of this area of law. Our consultees agreed that the 1861 Act is seriously deficient in a number of ways. The Act fails to provide a logical, structured hierarchy of offences of violence. There are too many narrowly defined offences dealing with the same subject. Some of the offences overlap unnecessarily, and that causes confusion. In many places, the language is obscure and archaic, and the courts waste time having to explain the real meaning of various legal terms. Some offences lack any clear definition, even as to their core elements, including the possible sentence available. The 1861 Act also includes numerous offences that serve no valuable purpose in modern society. Many of these are typical examples of the way Victorian statutes were drafted, with intricately detailed offences dealing with the different ways an offence might be committed. For example, there are offences of assault on those preserving shipwrecks, assaults on the clergy, and so on. If there is a clear workable offence of assault, these are unnecessary and have become obsolete in practice. It's a heavily amended Act described by one law lord as containing a ragbag of offences. Many of the problems in the Act are only avoided in practice because of the detailed CPS charging standards and the Sentencing Council guidelines. But it's wrong that these guides, and not the legislation, are what govern the way prosecutions are conducted. We're confident that the modified 1998 bill, which we recommend, would represent a significant improvement on the present law. The logical hierarchy of new violence offences in the 1998 bill has been widely supported on many previous occasions. It will mean that the offences describe more accurately and fairly what is alleged against the defendant. The offences require proof that the defendant intended or was reckless about the level of harm which he or she actually caused. So, for example, an offence of recklessly causing serious injury would require proof that the defendant foresaw that there was a risk of serious injury resulting from the conduct. We also make several recommendations that were not in the 1998 bill. First, we suggest the introduction of a new offence of aggravated assault that would deal with cases which, in the present scheme, fall somewhere between assault and actual bodily harm. At present, over a third of all sentences passed in the Crown Court for the actual bodily harm offence are under 6 months, so they are within the sentencing powers of the Magistrates' Court. We believe that the time-consuming and expensive procedures of the Crown Court are not necessary when dealing with low-level offences of violence of this kind. As at present, the basic assault offence will be triable in the Magistrates' Court and carry a maximum 6-month sentence. To reflect the fact that the new aggravated assault offence involves injury and is more serious, we recommend that it should have a sentence of up to 12 months, but be triable only in the Magistrates' Court. Looking at the current sentences for actual bodily harm in the Crown Court, around 70% of such cases are under 12 months, so could fall within that new aggravated assault offence. Secondly, we recommend extending the offence of making threats to kill so that it includes making threats to cause serious injury or to rape. That offence would carry a maximum sentence of 10 years imprisonment. Thirdly, we recommend that the offence of assaulting a police officer should require proof that the defendant was aware that the person he or she was assaulting was or could be a police officer. But we also recommend that the maximum sentence for that offence, which is triable in the Magistrates' Court, should increase to 12 months. If implemented, the recommendations in our report will produce a clear, modern, statutory code dealing with offences of violence, providing a coherent scheme of structured offences that can be readily understood and efficiently prosecuted. full report and a summary are available on our website.